our Rules as Code Masterclass with Data61 and QUT, our first in a series of 4 masterclasses. Let's begin by acknowledging the traditional custodians of the various lands on which we meet today and the Aboriginal and Torres Strait Islander people participating in this webinar. I pay my respects to elders past, present and emerging and recognise and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I am Natalia Crnomarkovic. I'm with EY Law and lead the Asia Pacific Law Innovation Hub and the Oceania Law Technology team. For those of you who are joining us for the first time, the Australian Society for Computers and Law was launched by the Honourable Justice Michael Kirby in July last year, but has a proud 40-year history in New South Wales. We are a cross-disciplinary network of professionals, academics and other leaders working at the interface of law, technology and society. We provide a forum for learner discussion and debate through our policy lab, working groups and events program, of which these masterclasses are one. We continue to attract support and engagement across Australia and globally, so do join us by subscribing to the AUSCL. As I mentioned earlier, this is our first webinar in a series of four Rules as Code masterclasses, showcasing platforms that are leading the way in shaping and defining Rules as Code initiatives globally. So on the 25th of March, we have a masterclass with Smart Legal, and on the 11th of May, a masterclass with AUSCL Datalex. Now for some quick bios. Today's masterclass will be run by Professor Guido Governatori and Dr. Alice Witt. Guido has a PhD in legal informatics and leads the Software Systems Research Group at CSIRO's Data61. His groundbreaking work on computer-based techniques for the representation of legal knowledge has been recognised in numerous awards over the years, including the BMP Business Process Management Test of Time Award and the Australian Computer Society Best ICT Researcher of the Year. Guido has served as chair of numerous international conferences on legal informatics, AI and law, and is co-chair of the OASIS Legal Rule ML Technical Committee. Now to Alice. Alice is a postdoctoral research fellow for the CSIRO Data61 funded project entitled Classifying the Legal and Coding Challenges of Digitising Commonwealth Legislation with the Digital Media Research Centre at the Faculty of Business and Law at the Queensland University of Technology. Her research investigates the exercise of governing power in the digital age, focusing on the intersection of regulation, technology and gender. Alice has experience in developing innovative digital research methods, embracing both qualitative and quantitative analysis. Before we start, Guido and Alice, could I please ask you to share how you became involved in Rules as Code? What excites you about this field? Guido, can we start with you, please?
So I've been involved in this area for over 2 millennia. So I started working when I was doing my PhD on the formalization of legal documents, legislation and regulations. And I would say possibly law, it's in my blood. So my father was a court judge and my mother was a law professor. So why not? So why not working in this area from a computer science and philosophical point of view?
Oh, fabulous. Runs in the family, definitely. Thank you for amazing work, Guido. Alice, what brought you to Rules as Code? What excites you?
Well, thank you, Natalia. And firstly, just hello, everyone. It's lovely to be here. I just wanted to thank the Australian Society for Computers and Law for inviting me along. So I first became interested and involved in Rules as Code through my current position as a postdoctoral research fellow. And it's really through this position that I've been able to delve into this topic and related statutory interpretation issues in particular. But I just wanted to say there that in terms of how I approach Rules as Code, firstly, it's from an academic perspective, as a legal scholar interested in those intersections of law, technology and society, and as part of this, based on practical experience, having translated legislation and other types of regulation into machine readable code alongside my QUT law colleagues over the last year, and alongside Guido as well. So generally across the board, in terms of the work that I'm doing at the moment, it really focuses on the intersections of public law values and regulation in the digital age.
Fabulous. Let's move on with the masterclass. We have over 300 registrations for today's session, so it promises to be an amazing session with hopefully lots of Q&A. Just a quick reminder, this session will be recorded, so please keep yourself on mute and cameras off. Please use the chat function for any questions. Now, Guido, over to you.
Thank you, Natalia. Oh, well, welcome to this presentation as Rule of Code, and this is a joint work, joint presentations by Alice and myself. So let me start with the agenda. And today, in the actual masterclass, we're going to have 5 parts. In the first part, I will give an overview of the benefits and the challenges of this approach. In the second part, we are going to look at the basic principles to translate pieces of legislation into a digital representation. And in this part, we will see how to use statutory interpretation, in particular what is called the modern approach to it. And this part will be done by Alice. Well, then we are going to the longest and unfortunately the most technical part, where I'm going to present a particular language, and I'm going to see how to do encoding in this particular language, which is called the feasible deontic logic. And finally, in the fourth part, Alice is going to present some lessons we've learned in the project we've done together on encoding different pieces of Australian legislation. And finally, we are going to have an additional part where there will be opportunity for questions and answers, and that part will be moderated by Natalia. So let me start with the benefit and what are the possible challenges for Rule of Code. So, well, a few years ago, the current Prime Minister, Australian Prime Minister, was really involved, and then essentially he had this statement here and says, well, we could have really big gain in productivities if we can have legislations written as code. And a few years later, and worldwide pandemic after, is still quite high on this idea, but as Prime Minister at that time was just the Treasurer. So how can we do this, and what are the possible benefits and what are the challenges we have to face here? So first of all, we have to understand that compliance, it's very hard, it's a difficult problem, and there are many levels why this is so. First of all, in Australia, we have at least 3 levels of legislation. We have federal, state, and local council. For example, in Southeast Queensland, if you want to operate a food van and you want to move from market to market, you have to comply with 27 different pieces of legislation. And if you move from Brisbane to Ipswich, 20 kilometers apart, then you add another 3 or 4 different pieces of legislation to comply with local requirements. Then also we have a temporal aspect, because we know that legislations, regulations evolve over time, and then essentially we have to understand what are the pieces in force at a particular time. And most importantly, business owner, in most cases, they are not lawyers, they are not legal practitioners, so they don't have a clear understanding of what are all different pieces of legislation that apply to them. So how can we help them? Can we make it easier to them to comply with all the requirements that they have to obey by law? Now, I said it's a complex problem and it's very, very expensive. Here are some old data. In US, a few years ago, it was approaching $2 trillion per year, according to the IRS, so the US tax office. In Australia, we were lucky, it was only 250 billion per year, But when we compare the size of the economy and when we consider in general OECD countries, the cost of compliance approaches 15% of GDP, which is a huge amount. In Australia, over 1 million people it's employed in compliance and compliance-related activities. Before the pandemic, it was about 9% of the workforce, and it was growing. Now, let us consider one example where we see what are some of the issues here. So every year, the Australian government has over 60,000 contracts with external parties. The average value for those contracts is $1.5 million. And typically, there are 10, 12 possible participants who are going to bid to get this contract. Now, to participate in the bid, they have to comply with the procurement legislation, and they have to follow, and they have to be strictly follow those regulations. If they don't, some of their proposal might be rejected, even if they are the possibly the best proposal. But if some of the aspects are not complied with, the proposal can be rejected without looking at the actual content of the proposal. And then only one bid will be successful. So it means only about 10% of the bid is successful. The other 90% will be work which is not productive. So how can we reduce? How can we make it easier for citizens and enterprises to work and comply with the legal requirements? Now, based on some of the experiments and pilot projects we have done so far, if you take an approach, a rules-based approach, and regulations are provided in as an encoding, then it is possible to reduce the cost of compliance by 30%, which means 5% of the GDP. So what is the idea? What is the platform we have in mind? And what is the platform we work on the past few years? So the idea is that, well, we continue to have that regulations are created, redacted, written, promulgated by regulators, parliaments, and the authorities who have the power to do so. And at this moment, we have that those pieces of regulations and legislations have to be translated, transformed into a format that is understandable by computers. So what we have, we imagine that we have a database of all legislations that are written in a logical format, in a digital format. Well, in the future, we can imagine that we can use some natural language techniques to semi-automatize this particular process of encoding legislations, but at this moment it's done manually. But after you have this format, this digital format, then you can have engines, you can have reasoners, you have techniques where essentially you can manipulate the piece of legislation and to determine what are the legal requirements in force in a particular situation. And if you have this, then, and you know what are the requirements, you can build applications on top where third party can provide their own interpretation, their own domain knowledge to enrich and to create more benefit to the public. So based on this approach, what we can see, we start from the regulation, we have the logical database, and in that language, in that format, we can have some normalized representation, and ideally, the legislations will be released as open data and possibly endorsed by regulators or any authorities who can enforce or have some power on those particular piece of legislation. And there will be a layer of APIs, so essentially ways to interface with the digital format of the legislation as open data. And after that, you can create many applications, as I said before, and I'm going to give some of possible applications we have developed in the past few years. Now, what is the key idea of legislation as code? We want to go a little bit beyond just rule as code. We want to have a full environment. Well, the idea is to have the legislation in a dual format. We want to have the natural language format, so essentially human can fully understand the meaning, but also when we want to have legislation represented digitally, we want to have that piece of legislation to be represented in a language which is at the same time understandable by humans, so human can read the interpretations provided by the formal, the digital version, and to understand what are the goals, what is the intent of the legislation. But at the same time, the encoding, the digital format, it's processable and understandable by machine. Here, the key point, more than understandable, it's processable. And then essentially we can perform computation, and computers are very good at that. So we might consider what are the eligibility criteria, what are the possible benefits that should be paid to particular subjects, and in general, we can determine what are the requirements for a particular situation. Now, in the past, we look at different normative frameworks, and this is just a list of some of the documents and acts, legislations, regulations we have encoded. So as you can see, it's a quite fair and long list, and despite we did cover different areas, and essentially say, yes, it is possible, but there are some aspects, and we have to understand what are how to do the encoding properly. Now, before moving to the second part by Alice, I just want to show some of the possible applications and what is possible if we have a digital representation of some piece of legislation. Well, here we start with those three possible applications. I want just to give a quick overview of the regulation as a platform application. I want just to show an idea of business process compliance, and then I want to show some ideas about one of the other projects where we did something a little bit more different. Now, the idea is to have this logical database, and essentially in the logical database, we want to have on one side the representation, the textual descriptions of the provisions and the formal encoding, and also we want to have some editor where you can work on. And then if you are able to do this, then essentially you can just show the rules as some form of graphs to understand what are the links between the different components, the different elements, the different terms and what conditions contribute to what conclusions and so on. And also, well, if you want to go on, you can create some modern art, and then essentially you can have a different kind of graphs to understand what are the different relationships and how the different elements, with the different terms, the different concepts in a piece of legislation are connected. So this is very helpful when you want to draft a piece of legislation or you want to do some amendment, because if you want to know what are the possible effects of changing one piece, one definitions, you can see what are the connections to the other terms in the piece of legislation. Now, after you have those pieces of legislations, you can apply in some applications. One of the application, and what we started from this work here many years ago, was what we call business process compliance. So a business process, it's a blueprint of how an organization do their activities. So this is just an example. And then what you can do, you can combine with the relevant legislation, and then at a click of a button, you can see whether the process is compliant or not. So essentially, you simulate all possible ways in which the process can be executed, and then you see whether there are some possible problems from the regulatory component. And essentially, the tool will also tell us what are the problems and provide some possible solutions. Now, the final applications we had was an experiment where we work with Part 7 of the Crime Act on about spent convictions. So essentially, what are the conditions under which a person who has been convicted has, or it's allowed not to disclose information about previous convictions. So what you can do, you can encode in a in the language, and we are going to see in more details in my second part, after Alice's part about interpretation. You can provide the data of a case, and then at the end you can discover what are the obligations in force, and also you can discover what are other conditions, other statements that are implied by the particular piece of legislation. Okay, before moving to the other part, now it's time to switch to the part on interpretation to see what are the key aspects to do when you want to do, and then I pass the baton to Alice.
Okay, thank you very much, Guido. In this part of the masterclass for around 15 minutes, I'll be exploring the concept of legal accuracy. So what it is, why it's important, and ways to promote legal accuracy when translating or converting legislation into machine-readable code. Before I delve into the specifics, though, I'd like to briefly provide some context. What I'll be sharing today are preliminary findings from an ongoing multidisciplinary and collaborative research project between QUT Law and CSIRO's Data61, which, as I mentioned before, both Guido and I are part of. This project is led by Associate Professor Anna Huggins with Chief Investigators Professor Nick Suzor and Associate Professor Mark Burden. So the objectives of this project are twofold. So the first is to identify areas of compatibility and difference regarding the application of processes of formal logic and statutory interpretation that are both required to convert Commonwealth legislation into machine-readable format. And second, to formulate a classification framework to identify the likely ease and difficulty of coding other Commonwealth legislation. I mention these objectives because, as Guido foregrounded, there are two main rules as code approaches. The first involves converting existing laws into machine-readable code, often for use as operational business rules by specific entities. And the second involves co-drafting laws in both natural language and machine-consumable format at the same time. In this ongoing research project, we are generating new knowledge particularly relevant to the first rules as code approach that can in turn inform the rules as code movement more broadly. So we expect to publish our findings in late 2021, so please do look out for those publications. So a critical challenge in rules as code initiatives is promoting the legal accuracy of encoded rules. That is, converting legislation into computer code in a way that aligns with the correct legal interpretation or true meaning of statutes. In the Australian context, this challenge is made more complex by the strict separation of judicial, legislative and executive powers in the Constitution, under which only the judiciary can authoritatively interpret the meaning of a statute. This principle of public law is not unique to Australia, but it has been applied fairly rigidly here. Even if a body of case law exists, the nature of the Australian common law system means that while similar cases will generally be treated alike in line with the doctrine of precedent, future cases with slightly different facts may trigger a reinterpretation of the law. An added complication is that the construction of statutes is a question of law and therefore open to appeal on the basis of error in statutory interpretation. So there are two important rules as code implications here. The first being that interpreters, or people attempting to convert legislation into machine-readable code, cannot definitively determine the extent to which their encoding choices are legally valid. A result is that my colleagues and I, and Guido, were careful to avoid making claims about legal validity and instead promote the importance of legal accuracy. This, in our view, is a really important point. The second is that due to Australia's constitutional framework, a limitation that will apply to any efforts to encode legislation, interpreters or coders should consider and apply the modern approach to statutory interpretation when attempting to translate the meaning of a statute into computer code. I'm now going to provide an overview of what the modern approach entails, but given the limited time that we have today, this overview is of course brief and very high level. There are a range of scholarly materials that explore this approach in detail, so please do undertake a bit of a Google search there if you'd like to see any more fine-grained detail on this. So the modern approach to statutory interpretation is the interpretive approach currently favoured by Australian courts and has emerged in recent decades against the backdrop of significant increases in the volume of federal, state and territory legislation. Project Blue Sky and Australian Broadcasting Authority provides the leading articulation of the modern approach, which is expressed in very clear terms in the quote on the screen there, which I'll now read. So the duty of a court is to give the words of a statutory provision the meaning that the legislature is taken to have intended them to have. Ordinarily, that meaning, the legal meaning, will correspond with the grammatical meaning of the provision, but not always. The context of the words, the consequences of a literal or grammatical construction, the purpose of a statute, or the canons of construction may require the words of a legislative provision to be read in a way that does not correspond with the literal or grammatical meaning. What this means for us is that the modern approach requires an interpreter to analyse the text, context and the purpose, sometimes called the policy, of the statute they are seeking to translate into machine-readable code. It is useful here to delve into what analysis of text, context and purpose actually entails. And for the lawyers in the room, a lot of what I'm going to say is likely to take you back to those early days of law school. It certainly did for me. So first, analysing the text involves locating and reading a specific statutory provision and identifying the key words, elements and conditions in that provision. So as all of you know, it's crucial to start here as the statutory text has specific legal authority. Second, context requires interpreters to read the select provision in the context of the Act as a whole. And finally, purpose or policy involves interpreters considering Parliament's purpose in enacting the legislation as evidenced by intrinsic and extrinsic materials. So intrinsic material is the Act itself, including legislation's object clause or clause, while extrinsic material includes the legislation's establishing documents such as speeches in Parliament or legislation's explanatory memorandum. As the quote from Project Blue Sky and Australian Broadcasting Authority, the case on the screen, makes clear, the modern approach can also involve consideration of canons of construction. So that is syntactical presumptions which relate to the meaning of the statutory text, for example, a justum generis, and or statutory presumptions which relate to the scope and the effect of legislation rather than the statutory language. So for example, legislation not operating retrospectively. As I mentioned before, any application of this approach must return to the statutory text to assign meaning to the provision and its key terms, elements and conditions. So this task is of course made much harder when the statutory text contains, for example, ambiguous or open textured terms or contains discretionary provisions. Importantly, as the Honourable Justice Michael Kirby states in the context of the modern approach, These and other explanations of the contemporary understanding of statutory interpretation have increasingly taken courts in Australia away from the previous literal or so-called objective or plain meaning approach to interpretation. This means that, to use another of the Honourable Justice Kirby's phrases, statutory interpretation is an art, not a science, in the sense that this work is complex, it's challenging, and it can lead to different answers, especially when a statutory provision is contested. This is, though, what makes statutory interpretation really interesting. So if we abstract up here, there are three key takeaway points today. So the first, to ensure legal accuracy in the Australian context, the starting point for any rules as code approach or initiative should be the modern approach to statutory interpretation. This approach, encapsulated by the phrase text, context, and purpose, provides a useful framework or a guide for construing the meaning of a statute. A major challenge, however, is figuring out how coders or interpreters can apply the modern approach using a particular coding language and within, to use Guido's term, a particular coding or encoding environment like Turnip. This can be time-consuming and quite intensive work, at least in the experience of my colleagues and I. We address this issue in our project by creating specific coding conventions and step-by-step procedures that are based on the modern approach to statutory interpretation and incorporate our select coding language, Turnip. So we'll be publishing these procedures, the step-by-step processes that we followed later this year. The second implication here is that there's an important distinction between legal accuracy in line with the modern approach to statutory interpretation, which I outlined earlier in my presentation, and coding validation. So from a technical perspective, we argue that an encoded provision is validated when it adheres in a formal sense to the select coding language and other relevant coding conventions. In a practical sense, this means that the code runs or it works and it produces a definitive outcome. Coding validation is also concerned with the degree of internal consistency between coders to ensure that encoded rules for the same piece of legislation work together. So while both legal accuracy and coding validation can be measures of the apparent success of encoded rules, they are different and should be treated as such. My final and concluding point is that statutory interpretation is critically important in promoting the legal accuracy of encoded rules. In Australia, like other Anglo-American societies that strive to uphold the legal ideals of the rule of law and the separation of powers, the modern approach to statutory interpretation serves as an important safeguard against possible inaccuracies and uncertainties in rules, whether written in human and/or machine-readable formats, or both. These considerations are important for a range of stakeholders, including potential end users who might, for example, rely on regulatory technology, RegTech, to comply and stay up to date with regulation governing their commercial activities. Also for governments that must exercise power in accordance with established rules and principles, and technology companies and other stakeholders that are investing significant amounts of time and money in rules as code initiatives. It is critical to keep these high-level ideals, the rule of law and the separation of powers, in mind at every step. So thank you very much. I'll now hand back over to Guido for the next part of this masterclass.
Yep. So thank you, Alice. So it's now time to move to see how to do the encoding and essentially how to apply some of the principles explained by Alice. So here we're going to see what is the background behind our particular approach, and the background is given by what we call computational law. Well, computational law, it's just the use of formal methods, logic, mathematical, computer science, artificial intelligence, and similar techniques for the representation of a normative system. As we will see, a normative system in our definition, it's just a set of rules, it's a set of provisions, and the aim of computational law is to determine what legal consequences are in force in a particular situation. And then if we are able to determine what are the requirements in force, what are the requirements that hold in a particular situation, then we can determine whether they've been complied with or if we have some possible violations. And also, in some cases, to see whether it is possible to recover or compensate for the possible violations. Okay, let us consider this example here. This is just let's say, an hypothetical clause in a Privacy Act. It's somehow inspired by the Australian privacy principles. So most of the structures I have here are present in actual provisions in the Privacy Act, not this particular one. So as you can see, you might have different sections, and then very often these sections will provide just the basic idea. You will have the header of the sections, and then essentially they specify what is the main idea of the section. So in this case, sections 1 establish the prohibitions to collect what is called personal medical information. Now, in modern Australian statutes, very often you will have the distinctions between what is an offense under particular sections and what is a defense. So this is just to provide a proper definition, and also we can understand how to structure the encoding after that. Now, here, what we have to do is we have to understand that defense, it's used for different particular purposes. One purpose is to identify what are the possible exceptions, but when you look at this example here, you can see that it is possible to use in a slightly different way. Because when we look at defense under section 1, the defense provides a way to recover or to compensate from a possible violation when you do something which was not explicitly allowed by the provision. But also there is a difference in the use of offense and defense, because essentially it also establishes what is the burden of proof and who has the burden of proof in case you have to go legal proceeding. So here what we do, we have the offense set at the baseline condition, and then in this case, when we look at sections 1, we will have some, as I said before, we have some possible ways to recover if something illegal was done. Now, when we look in section 2, we will have that some conditions allows us to permit has to do some particular activities which might otherwise be forbidden. And then when we look in section 3, we have something similar to the first sections, but in this case, it's structured as a defense, but in this case, it will be an exception. So essentially, these section 3 somehow derogate to what it's. So the defense is how ways to derogate to what it's established normally by the section. So here, essentially, the aim of the possible encoding in computational law is to determine what are the requirements, the legal requirements in a particular situation. So what about a situation where an entity collects some personal medical information without being permitted, so there was not an authorization to do so. At the same time, they were collecting some personal information, and here for the purpose of this example, we can consider those two completely disjoint. So they realize that the collections was illegal for medical information, so they destroyed. Do they comply with the act or not? So here this is somehow as reasonably, well, it depends, it may consider as a simple problem or not, but essentially we have to formalize and you have to provide the answer which is in agreement what will be the answer given by a legal professional. Now here we can see a second example. Let's say this is from an agreement for evaluation for product. So essentially that it will be a license. And then essentially you can have multiple sections, multiple articles, and then the article can give different conditions. Here, what we can see that when we consider the content, we can see that section 2 has the same structure essentially as the defense in the previous example. So it provides some way to recover in case there are some possible breaches of this particular agreement. And then also we have other conditions, and we will see some other aspects in later part of today's presentation. Now, so the aim, as I told you, is to understand what are the legal requirements that hold in a particular situation. And here let's start on how to represent them properly. So as I said, we will consider what we call a normative system. And a normative system is just a set of norms, a set of rules, and then essentially they are represented by a set of clauses. Then for every clause, we can represent it as a rule, in particular as an if-then rule, where we're going to have the if part, and the if part is the condition, so A1 to AN is the if part, and then we're going to have what we can call the effect of the norm, the normative effect of the norm, which is the then part. In this formal representation, the effect is C, it is what is on the right-hand side of that arrow. Now, when we consider the clauses, when we consider the rules, we can distinguish between two different types of rules. We have what we call the definitional rules, also known as constitutive rules, and those rules are meant to define terms to be used in a particular document, in a particular legal context. So what is the meaning of a particular term in a particular act? Normally, we can use, as Alice said, the common interpretation based on the interpretation, but if that is given, if there is a proper definitions given in a particular act, then essentially we have to take that particular definition, and also we have to expand, as Alice said, based on all the other conditions. Now we have a second type of rules, and we have what we call the prescriptive rules. And the idea of a prescriptive rule is to identify what are the normative effects, where effects can be that something is an obligation, something is permitted, something is forbidden, or we have a prohibition, and then essentially we can determine whether there are some possible violations and compensations. So those are the types of effects we have. And the idea of an if-then rule, A1 to AN, then C, is that, well, the if part, A1 to AN, gives the conditions under which the rule applies, and C gives us the effect. So essentially, what is the obligation in force in a particular situation? Now, a very important aspect, if we want to encode in a natural way, is to understand that rules can be defeasible. So essentially, when you look at statutes and other type of documents of this kind, then you will see that in general, you're going to have a baseline condition, a rule for a baseline condition, and then you're going to have generally long lists of exceptions. And sometimes you're going to have a list of exceptions to the exceptions. In more rare cases, you have exceptions to the exceptions to the exceptions. And we were also able to find some situations where there were exceptions to the exceptions to the exceptions to the exceptions to the exceptions. So there were 5 levels. However, those are rare, and in general, if you have more than 2 or 3 levels, it means that documents are not really easily understandable, but the representation, the formal representation, can help you to have a better understanding because it makes explicit all those levels. So we said we have the normative effects. So essentially here we distinguish between obligations, prohibition, and permission. Here it's the definitions given by the OASIS Legal ULML committee. So an obligation is a situation, a course of actions where a subject is bounded, and then we have a violation if the act is not achieved or it's not performed. A prohibition is similar. It's something a subject is bound, and we have a violation if it's done instead of prevented. Finally, we can speak about permissions, and then a permission is a situation where a prohibition doesn't apply or the obligations to the opposite does not apply. Now, when we consider those three types of normative effect, obligation and prohibitions can be violated, and in case we have violations, in some situation it is possible to have some possible compensatory measures, so they can be compensated. However, permissions as plain permissions cannot be violated, and then it's not possible to have compensation. You cannot have a compensation without a violation. Oh, this is just about some of the symbols and terminology we're going to use in presenting in the formal, in the encoded way in the rest of this section. Okay, consider this small fragment. Let's say it's a fragment of a contract, and then essentially we have some clauses. Now, here the exercise is to understand what types of clauses we have in this example here. So what about section 3.1? For me, this section just provides a definition, so we can use just a constitutive rule, and then essentially tell us how to classify a customer and what are the conditions to classify the customer as a premium customer. Now, what about section 3.2? Well, here we can use the it depends, which is very common for a legal professional. So every time you ask a question to a legal professional, the answer is it depends. And then essentially, based on some possible qualifications, you can determine what type of legal professionals you have, whether you have a very long explanation. It might be a law professor. If you have a definite solution and even longer explanation, that possibly you have a judge and so on. However, let's go on. So what is here? What do we have here? Now, here we can see that under particular interpretations, we might see this definition, this clause as a definition, giving us a recipe to compute a special order. And also in this case here, we have another particular aspect, because when we look at the second part of this statement, of this expression here, we have the sentence, the premium customers are exempt from special orders or charge. So essentially, we have a baseline condition, a baseline definition, and also we have an exception. So something which is not how to compute based on the baseline condition in case somebody is a premium customer. Okay, now let's move to 5.2. Well, this should be a reasonably clear case. Here we have an important keyword, we have shall. So this indicates that this particular provision, it's a prescriptive clause, and then it generates an obligation. What about 5.3? Well, first of all, we have some reference to 4.1 or 4.2. We have no idea about the content of those two possible clauses, but we have the indication is that if they are not met, then something else is going to happen. And then we have essentially, in case the conditions have not been met, so it implies there is a possible violation. And essentially, for me, the most plausible reading is then this provide some compensatory clauses. In particular, it gives us, if there is a violation for what is specified in 4.1 or what is specified in 4.2, then one of the parties is entitled, it's permitted, and then the rest of the condition. So when we consider just those 10 lines or less, we have examples of definitions We have example of provisional clauses. We have example of the feasibility of exceptions. We have example of obligations. We have example of compensatory clauses. So clauses that hold in case we have some violations. Now, what about if instead of less than 10 lines, we have 10, well, one document with 100 pages? How many of them do we have? So it means if we want to be able to represent properly and to encode properly large piece of regulations and legislations, we have to capture all the aspects I've mentioned. Definitions, prescriptions, to handle obligations, permissions, prohibitions, and possibly compensation. And we have to consider also how to model exceptions. Okay, then I've mentioned exceptions, so let's see how to do with them, and let's start from this aspect. Well, let's start with a concrete example. Let's take section 2.1 of the Telecommunications Consumer Protections Code, and the idea of this section is to provide the definition of a complaint in the telco sector. And here, essentially, a complaint is just an expression of dissatisfactions about a service or a product. And then where also there is another conditions because you have a complaint that you want a possible solution. Now, then when we go to the second paragraph, we have some qualifications about what is a complaint and what is not a complaint. So it said, well, when we receive an initial call, it might not be a complaint. It might be, but it's not necessarily a complaint. And in general, when you get an initial call reporting a fault or a difficulty, then that it's not a complaint. However, and here we can consider when we have a possible exception to this, if the customer advises that, yes, it is an initial call, but it should be treated as a complaint, then the call, even if normally would not be a complaint, it is a complaint. So again, baseline condition, possible exceptions, and then also exceptions to the exceptions. And we have a similar situation when we consider, for example, sections 29 of the Consumer Credit Protection Act. Here we have the baseline condition. A person must not engage in a credit activity, so there is the prohibitions to engage in a credit activity. And then what we have here, we have also an exceptions directly in sections 1. We have the if the person does not hold, which can be understood unless condition. So baseline, it's prohibitions to engage. However, it is permitted if you have a credit license. And then essentially we can go on in section 3, and that's, if I remember right, section 3 it's about 5 pages. You have 5 pages establishing all possible exceptions when a person without a credit license can engage in a credit activity which would be otherwise forbidden. Now, after the 5 pages, there are another couple of pages where you have the exceptions to the exceptions. So it's very, very long, and we want to have efficient and concise ways to capture those constructions. So what is the general structures we can do to model the exceptions? And then here we want to see one particular way. And essentially what we want to do, we want techniques where we can capture the individual provisions, the individual sections, the individual subsections, the individual components, and model them one by one. We don't want to have a very long list where we have very long and convoluted if-then-else conditions, because they will come very easily unwieldy and very hard to unravel. So what we can do is just to have an if-then conditions at the beginning, just for the baseline condition. So if person, then credit activity is forbidden, it will capture the baseline condition. Then the second rule, R2, will capture the unless condition. If the person owns a credit license, then the credit activity is permitted. And then essentially we can go on with the individual subsections, and then we can consider what are the conditions. So, for example, in 3, if somebody is a person, and the person acts on behalf of a principal, and it's the employee for the principal, then it's permitted. Now, here, when we consider just the rules, we can say that, well, when you consider R1, the rule established that the credit activity is forbidden, and then Rule 2 and Rule 3, they say that it's permitted, and essentially, we don't want that something is at the same time forbidden and permitted, otherwise how can we know how to do it? What we can do is to have an override relations, and then we can specify that some rules are stronger, override other rules. So in this case, R2 overrides R1 and same for R3. So in this way, we can encode the individual provision individually, and then we can establish the relationships between those conditions, just specifying that one rule defeats, override, it's stronger than the other. Now, let's go to the next part. And we saw that we have the aspect where we want to capture the normative requirements, so the effects, obligations, prohibitions, and permissions. So what we have to do is to extend the language with what we call the deontic operators. In particular, we just concentrate on obligation and permission, and also as prohibitions after. And essentially, the idea is that they qualify particular statements. So let us consider those three statements here. In the first case, we have a statement that establishes just a Boolean condition, a condition which is true or false. This condition specifies, well, if something is a special order, if X is a special order, if X is the price of a special order, this is computed by taking the price of X and then adding 5%. And then essentially we have just to check the two values and to see whether they are the same or not. Then we can consider the other, so we might take another Boolean expression, which is something which can be considered true or false, or evaluated as true or false, whether a good was made available within 1 day. And then essentially we can qualify. Here also we can specify who's the subject of the obligation, and essentially we can transform into an obligation putting into the scope. When we read these expressions, mean it's obligatory for the supplier, to make goods available within 1 day. And similar for the other, it means the purchaser, it's permitted to charge the supplier, and then essentially we can go on. Okay, so here we said, and in the example about the prohibition and permissions to engage in accredited activities, we said, well, we don't want to have the obligation and the prohibition and the permission at the same time. So here we have to understand what are the relationships between obligations, permissions, and prohibition. So the obligation of something is equivalent to the lack of the permission for the opposite. So if it's obligatory to pay taxes, it's not the case that you are permitted not to pay taxes. And also, well, if you are permitted to take a break, then essentially it's not the case that you have the obligations of not taking a break. What about the prohibition? The prohibition essentially it's an obligations plus a negative condition. So suppose that we have the norms that says that it's forbidden to smoke, then it means it's obligatory refraining from smoking, or not smoking, it's obligatory. And then essentially when we consider the or combination, we have that a prohibition, it's equivalent to it's not the case that what is forbidden is permitted. So if you have the prohibition of smoking, then not smoking, it's not permitted. Well, finally, the final condition is then, well, you cannot that something is at the same time obligatory and forbidden, so you will get something that is a contradiction. And then also it gives us the case that you cannot that something at the same time forbidden and permitted, just apply the different conditions. Okay, let's go back and let's consider further about the exceptions, and let's move how to do proper in the language we devise. So this is a long list of property of the logic, and for us, what we want to do is consider this aspect here. So it has constricted, so you have to be very, very precise when you do computation, but also it's constructive. So it means that every time we do some computation and we determine some particular effect, we determine some particular conclusions, then we can give a complete trace. We can justify every statement, and for every statement, we know what are the cases of what are the facts of a cases that contribute to that particular conclusions, and what are the rules used to justify every particular steps. So we have a complete trace, and for every trace we have a full justification. So this is very important because essentially, whenever we provide a particular conclusion, whenever we have a particular assessment, we can trace back and we can provide a full justification. So essentially, humans can consider whether that it's the right, it's properly aligned with the interpretation given that can be given by, let's say, legal professionals. So when we consider the logic, what we do, and for us, we will have two types of conclusions. We have conclusions which are called definite, so essentially that it's something given, and then essentially it's not possible to change if different facts were provided. But we also have what we call the feasible conclusions. So the feasible conclusion is essentially what we can prove, what is the best conclusions we can put forward with and only with the information provided in a given case. Then, for the information and different knowledge, we can have facts, so something which is true or false in a given situation or case, and we will have different type of rules. For us, we can just concentrate on the feasible rules, and essentially those rules, the meaning is, well, typically, normally, unless there are some possible reasons against it, we have B given A. And also, as I said, we will have the superiority relation in case there are rules which are in conflict, and then we want to specify that one rule overrides the other rule. Now, how can we reach conclusions? So what we can do, we can start with an argument for what we want to conclude, for what we want to prove, and then we have to consider all possible counter-arguments. We have to see whether there are reasons against it. And then, if we want to prove our argument, then essentially we have to rebut the counter-arguments. And to rebut the counter-arguments, we can defeat a counter-argument and say, well, my argument was stronger. So my argument prevails over your argument. Or the other alternative to undercut is to provide, to show that, well, some of the premises of a counter-argument do not hold in the particular situation. So let me go on and just consider a particular example here. So let us suppose that we have given those 4 facts, A1, A2, B1, and B2, and we have those 5 rules. 2 rules for C and 3 rules against it. And also we have those instances of the superiority relation. So R1, it's stronger. So this rule, it's stronger than this. This rule, it's stronger than this, but this rule is stronger than that. So what should we do if we want to conclude C? First of all, we have to give an argument for C. So here what we can do, we can use this rule here and this fact. So this fact is given. I have the rule. If part of the rule holds, so I can conclude tentatively C. Now let us consider the possible counter-arguments. The counter-argument can be built by either this rule or this rule or this rule here. So for R3, the rule holds. I have the premise, it's given, but I have that rule R3, it's weaker than rule 1. So essentially it's defeated. I say, well, my argument is stronger than the counter-argument. We can do the same for R4. Here, what we do, we have to use a slightly different argument because we have to say that, well, we can consider your argument, but I have the argument provided by rule R2 and A2. And that argument is weaker. Now, finally, we have the final possible counter-argument provided by R5, but we do not have the premises. Maybe they're old, maybe they're not, we don't know, but they are not given in the case. Since they are not given, we assume they do not hold, and essentially, even if the argument were stronger than my initial argument, I cannot use it because some of the premises are not known to hold. And so essentially we can reject it. And we can conclude C. Okay, let's see how to use it to model the complaint case. So essentially we said that a complaint is an expression of dissatisfaction. So if you have an expression of dissatisfaction, it's not a complaint. If you have a first call and it's an information call, it's not a complaint. If you have a problem call and it's a first call, it might not be a complaint. So we can use a defeater. I didn't explain defeater, but essentially said it might be, but it's not necessarily. And then finally, we can say, well, if the customer advises that it's a complaint, then no matter what, if there were even the call normally would not be considered as a complaint, since there was that particular statement, then it becomes a complaint. And also here we can specify which rules override the other rules. So typically the second call, information call, will defeat the first, and then essentially if you thought somebody advises a complaint, defeat that it's not a complaint. So in this way, we can just easily model the definition of complaint in the Telecommunications Consumer Protection Code. Okay, let's move at the part where we expand the language with the deontic concepts. Now, here we have to, first of all, we have to have two different types of rules. So as we said, we will have constitutive rules for the definitions and prescriptive rules for obligations or permissions. So we can strictly speak of prescriptive rules when essentially the rule is for an obligation, or a permissive rule when it defines a permission. We extend the language as we outlined before with obligation and permissions. Also, to capture possible compensations, we introduce this operator here, and we can build expressions like this. What is the meaning here? What is the meaning of obligation A, the strange operators, obligations B, strange operator, obligation C? The meaning is that the obligation of A is enforced, so we are obliged to do A, but if we have a violation, so if you're in situations where obligation A doesn't hold, then the obligation of B is in force because we have the violation, and doing B compensates for the violation. So essentially, we are excused for violating the initial obligation. However, even in case we fail to comply with obligation of B, so we have not B, we have a violation, then doing C is obligatory, and doing it will compensate for the violation of B, which in turn will compensate for the violation of A. Okay, now let us go back to the example and we will see how to model this. So let's concentrate for this moment on section 2 and section 5. So here we have that the license forbids the licensee to publish the result of the evaluation of the product without the approval, and of course they have to obtain the approval before publishing it. However, if for some reasons the evaluation of the product were published without approval, then the licensee has 24 hours to remove the material. Section 5 is just a termination condition, saying, well, the license terminates in case there is a breach of this agreement. So what about situations where the licensee, without an approval, published the result, but then they take them down within 24 hours? Do we have a breach of the agreement or not? Well, of course, we might discuss, and we can always use the infamous "it depends," but my reading is, well, here you have an explicit compensatory clause, so essentially you have to use it. So it would allow for this kind of situation. And then in case we have that it's published without approval, but it's taken down within the allotted time, then essentially it doesn't constitute a breach. However, when we consider, for example, Section 3, so the prohibition to post a comment on social media about the evaluation, let's ignore the unless part for the moment. So if somebody does, then essentially that will be one reason to terminate automatically the license. So here what we have to do is to understand what does it mean to have an uncompensable obligation and a compensable violation. So here we will have a prescriptive rule with A, B, let's say, and C just for example. And essentially, here you say you have the obligation of A. If violated, you can compensate by doing B. If violated, you can compensate by doing C. If you have not A, not B, not C, essentially you exhausted all possible ways to recover from the initial conditions, and then essentially we have something cannot be compensated. Okay, to conclude this part, let's see how to encode this license agreement in our particular formalism. So here, let us consider what are the conditions. Section 1, Article 1, it just provides the license, so essentially it permits the licensee to work to use the product. We already discussed Section 2. Section 3 specify, well, that the licensee cannot post on social media unless the licensee was permitted to publish the result of the evaluation. And here the important aspect is, well, what about if the licensee publish when without the approval? So is the licensee allowed to publish on social media, post comments on social media or not? Well, since it was not permitted, then in this case it will be not. Section 5 is just an additional condition that if somebody is commissioned to perform an independent evaluation, then they have the obligation to publish the evaluation. And finally, as we discussed before, 5 is the determination condition. Okay, first of all, it's what you have to do is just to break into single pieces, into single components. Here, what we can see is that when we consider the first condition, C0, it's something which was not explicitly given by the license, but it was, I would say, implied by the context that you have a license. And essentially, the license allows you to operate and to work and to use a particular product, and without the license, you will not be allowed to do it. So this means that the use of the product is forbidden, and then essentially this is it's understood by the context, because you have the license, and then what is the possible purpose of a license. The second one is C1, and that this is the basic condition. So if you grant a license, then it is permitted to use the product. C2 is about the prohibitions to publish the result of the evaluation. C2 is the compensatory measure. So if you illegally publish, so essentially if you publish when you were not allowed, but then you remove, you take down, then essentially that is a compensation. However, you say that the publication, it's permitted if you had an approval, and the approval was before. We have the prohibition on posting on social media. We have the condition that says corresponding to the unless part. So if you were permitted to publish the result of the evaluation, then you were permitted to post on social media. We have the obligation to publish if you had the conditions to do the evaluation. And now here, I would say, if you were commissioned, you also have the obligations to use the product. So again, this is not an explicit condition in the license, but it's implied by the meaning, and without, we don't know whether it's also or not. And finally, we have the termination conditions we discussed before. For any violation, or better for any violations that cannot be compensated, and it has not been compensated, we have to terminate the license. And then what does it mean to terminate is then essentially the use of the product is forbidden. So how can we model this? So we can just use this particular set of rules here. So initially, obligations not to use. If you have the license, then you are permitted to use. And then in general, when we have a condition that provide an exception, the condition for exception is stronger than the original condition. And so we can put the superiority relation, say that R0 it's weaker than R1. Then we can go to the conditions that say, well, you have forbidden to publish, obligations not. Remember that obligations not is a prohibition. And then that will be compensated by removing. If you get the approval, then you are permitted to publish. Here, when we consider R2 and R2E, we have conflicting conditions, which are obligation to publish and permitted not to publish. So we can put the superiority relation. We have R3, which is just the basic condition, prohibitions to post comment on social media. You have a condition that allows you to comment, it's permitted to comment if you are permitted to publish. And we have the two conditions about when you get a conditions. This strange symbol here, it's just to say, well, we got a violation. So essentially, if we have some obligations or prohibitions, and essentially we exhaust the possibilities. So if we have, for example, R2, it enforces the first case and the second, and we fail to do it. And then we have just to put the superiority relation. So as you can see, you can have a compact and concise and hopefully understandable condition of what it does for this one. And essentially this is done by looking at the provision, understanding what are the relationships, understanding the meaning, identify and split the meaning into the basic component, and in some cases you have to add some additional elements that are either implied by the context or by the purpose of the document, as I said by Alice about the interpretation. So if you want to play, you can download Spindle. Spindle is an open source implementation of the logic. You have to put some additional configuration. If you want to play online, this is a link where you can play online. And then it's time to Alice to go on and to provide the lessons we've learned by doing the exercise of encoding different pieces of Australian legislation.
All right, thank you again so much, Guido. In this final part of the masterclass, I'll be outlining some of the lessons that my colleagues and I have learned over the last year, particularly some of the coding and the legal challenges that we faced when converting different types of regulation into machine readable code. So I'm going to be brief, but I'm happy to expand upon any of the points that I've raised in question time. For our collaborative project, we translated 3 different types of regulation into machine consumable code. The first, as you can see there on the screen, we translated part of the newly enacted Consumer Data Right, or CDR regime, specifically 71 provisions of the Competition and Consumer Act and the corresponding Consumer Data Right rules. Second, we translated the entire Electronic Funds Transfer Code of Conduct, known as the e-payments code, a voluntary industry code of practice that provides a range of protections for consumer electronic transactions. And lastly, we converted select provisions of the Copyright Act pertaining to Part 3 works and related case law. So today, in the interest of time, I'm just going to focus on our learnings from the CDR regime. And on this note, it's useful here to briefly explain that the Consumer Data Right is a complex data portability regime that amalgamates competition law imperatives, consumer protection ambitions, and a newly implemented information privacy law framework that aims to promote consumer trust. So under the CDR, data portability is largely viewed as a competition enhancing mechanism to stimulate digital economies by, for example, preventing monopolies of valuable data sets and vendor lock-in. And the CDR is very newly enacted. So overall, we faced a range of technical and legal challenges in the context of the consumer data right, all of which sit under the overarching challenge of promoting the legal accuracy of encoded rules, which, as I mentioned earlier, refers to converting legislation into computer code in a way that corresponds with the correct legal interpretation or the true meaning of a statute. So some of the common legal challenges that we faced are listed there on the screen. So first, we encountered ambiguous and discretionary provisions. So ambiguous wording, which was common in the CDR, makes it difficult to convert rules into deterministic code because the meaning is unclear. In these instances, the modern approach to statutory interpretation is really helpful as interpreters consider context, purpose, and also canons of construction for resolving some of these ambiguities. It's also really challenging to convert the exercise of discretion into code. For example, some CDR provisions contain the highly contextual term reasonable, which involves discretionary judgment. A major problem here is that what is reasonable is likely to differ depending on the circumstances and over time, and there is no CDR case law to date to ascribe meaning to what constitutes, for example, reasonable costs or what is reasonable having regard to certain criteria. So terms that employ a reasonableness element are not well suited to conversion into deterministic computer code, particularly in the absence of case law that helps to clarify statutory meaning. To address these concerns around ambiguous and discretionary provisions, we flagged the need for human interpretation in the human readable description of relevant terms, using symbols, for example, but a more robust solution would be beneficial. Overlapping provisions in the same Act and also across statutes are also challenging to deal with in practice. For example, the CDR framework spans multiple statutes with a complex interplay of different legislative and regulatory requirements. This required us to work across multiple sources of law and extrinsic material, which was not only time-consuming, but also increased the potential for confusion among team members. Some provisions in general are more suited or less suited to conversion into computer code. So we found it difficult to accurately encode provisions that set high-level standards or aid interpretation, for example, interpretive notes or tables. And here we therefore recommend that interpreters undertake a comprehensive assessment of the potential value of converting certain provisions at the start of a project. So this can then guide some of the decisions that are made and also where focus is given throughout the entire project. Finally, it's essential that encoded rules are up to date. So of course the law is constantly evolving and it's vital to ensure that encoded rules are up to date and those developments are reflected in the code. And this requires significant investment in time and money, but is certainly something that should always be at the forefront of different rules as code initiatives. So we also encountered several technical challenges there on the right-hand side of the screen that are inextricably linked to legal challenges, hence the arrow there. So the first technical challenge is converting legislation into machine-readable code with varying degrees of experience in computer programming. So we identified this challenge because while all of our coders are legally trained, only some also had a background in computer science, which meant that we had to bridge disciplinary knowledge gaps. So in light of these gaps, our team had to spend a great deal of time developing a standardized approach to coding style, naming conventions, and so forth. A result is that we often worked in teams of two and regularly convened for group meetings to troubleshoot or to work through different issues, and it helped a great deal to have Guido in many of those meetings. We found, though, that people with legal expertise were able to easily learn the logic and the syntax of turnip language through several training sessions, much like this masterclass, and by experimenting with the code in an interactive interpreter like TurnipBox. Another challenge was setting up our coding infrastructure. So this required a significant amount of trial and error and tailoring our setup to enable our geographically dispersed team to work anywhere and at any time. So in the end, we had a fairly complicated setup. We largely worked through GitHub, which hosts our private, shared, and single project repository. We use Git for version control and GitHub for issue tracking, project management, and collaboration. We wrote the code in Atom, a free open source text and source code editor. And as I've mentioned before, we used Turnip language. We found this setup particularly useful for asynchronous coding, as our team largely worked at different times. But in general, as I said, it did take a fair amount of time to iron some of this out, but in the end, we got there. So finally, integrating different encoded rules into a cohesive whole is a really complex task. For instance, this challenge arose when coders translated different provisions, which are part of the same division of an act, so they then had to work all together. So particular challenges for integration include coders having different coding styles and also languages like Turnip enabling coders to achieve the same results, but in different ways. So we found GitHub particularly useful here for integration, as it shows changes and helps a team identify differences between coders. And GitHub was also really useful for establishing clear and comprehensive coding conventions from the outset and having it all in one place. So in sum, there are a range of legal and technical challenges, and of course broader social and ethical challenges too, that are associated with rules as code approaches that are premised on converting existing complex legislation into computer code. And that is the first main approach to rules as code that we're concerned with in this research project. So the second main approach, which involves drafting legislation and an official coded version in parallel with the aim of increasing alignment between the two, may help to address some of these challenges that I have identified and certainly warrants further research and investigation. So while we faced a number of complex challenges, legal and technical, there are a lot of possibilities and opportunities in this space. Our experience underlines that making the most of these possibilities really requires multidisciplinary expertise across the fields of law, computer science, and public policy. Also, from our perspective as legally trained coders, we argue that it's vital to have both subject matter expertise, for example, say privacy law or copyright law expertise, and also statutory interpretation expertise as part of this multidisciplinary team. So it's highly unlikely that all of these three main skills will be found in a single person. We think it will almost always be desirable to build teams that have these complementary skills between different team members. And this really underlines the need for more investment in rules as code initiatives, more people with diverse skills and from different backgrounds, and continued enthusiasm and drive to tackle some of the complex issues that arise in this context. And really, hopefully all of you, those that participated live and those watching this recording at a later date, can be part of meeting these challenges. So I'm going to leave it there. Thank you very much. And I'll now hand back over to Natalia.
Thank you, Guido and Alice, for sharing your deep expertise in rules as code. Your work, collaborating there at the intersection of law, computer science and public policy, is truly inspirational. Now for Q&A. Thank you everyone for your questions. Given the time available, I've selected 5 questions, starting with the broader questions first. Okay, Guido and then Alice, this is a question for you both. What do you see as the key benefits and challenges to widespread adoption of RAC? Guido.
Well, the major benefit will be the reduction of cost of compliance and making the legislation more accessible, and will be accessible both to the, let's say, third party to create additional application, and then essentially at the end to make the law more applicable and more usable by the final public, so the citizen and enterprise through third parties. The challenges will be that we have to do it properly, and it will be about the selection of the languages for doing the encoding. And the other challenge will be the sheer size of the regulation and the time it takes to do the encoding, because it will be very, very large and it's time consuming. And at this moment, there are no shortcuts, it must be done manually. So that will be the major challenge. And the benefit is, yes, it's, let's say, increase access to justice.
Yes, thanks, Natalia. And yes, I just wanted to echo what Guido said, particularly around there with the benefits. Certainly, for example, you know, being able to promote or enhance drafting processes, for instance, pick up on ambiguities and so forth. But in terms of the challenges, certainly the foremost that comes to my mind, and certainly that of my broader research team, is really promoting legal accuracy in those encoded rules, just ensuring that there's alignment between the encoded rules and the source, the statutory text. And as part of that, of course, you know, you've got to have, or to be across those key statutory interpretation principles and skills, or the modern approach. And also, lastly, just bridging those, I think, interdisciplinary gaps certainly is so fruitful and exciting, but it certainly requires a great deal of time and work. But I suppose that's one of the great things about Rules as Code initiatives.
Thank you, Guido and Alice. Next question, quickly, what are the major risks for the RAC approach?
Well, for me, the major risk is doing the encoding, not taking into account the legal background. So I fully second what Alice said for the previous question, and it's very, very important to do the encoding based on proper interpretation, legal interpretation principles. It's reasonably easy to do the actual encoding, but what is the hard part is to get the right content and the right intent, and then that can be only fully determined by applying legal principles. And that's why, as Alice said, collaboration and heavy involvement from legal professional, it's absolutely essential. The second part is the benefit is, I would say, from my point of view, most of the encoding should be done from the regulator point of view. And the real challenge and risk is not doing properly. So they have to take some risk. So they have to evaluate essentially what will be the best approaches and what will be the best piece of legislation, regulations to use in a rule of code approach. So potentially we can encode many different pieces of legislation. Some will have some benefits, and then essentially that is also to identify where to invest, because as we said, it will be expensive and time consuming. So proper investment is needed, and to identify where we get the higher return of investment.
And I'll just jump off what Guido said there. And to me, at least one of the foremost risks is potentially conflating what is promoting legal accuracy and also coding validation, as we explored earlier in this masterclass. It's really important to separate those concepts, both in theory and practice. Most importantly, as Guido was saying, to ensure that, you know, we're encoding rules in line with well-established legal ideals, like the separation of powers between the judiciary, legislature, and the executive. Only the courts can authoritatively state what the true meaning of a statute is. So understanding that there is an important distinction between legal accuracy and coding validation. They're both very important but distinct, I think, is something that's really important to keep in mind, especially because it can be a significant risk.
Thank you. We need to fly through the next 3 questions. So a question from Mick. In essence, is coding legislation an effective means of identifying inconsistencies in drafting? Guido, can I ask you to take that on? And then Alice, I have a question specifically for you.
Definitely, you can use the encoding to identify inconsistencies. And in some of the pilots we did, we got a couple of inconsistencies, or we've got some situations where the encoding showed that the interpretations might be a little bit different from what was the initial intent. In some cases, they were able to rectify because they were still in early phase of drafting. In some of the cases, they said, well, okay, yes, we understand, but it's very unlikely that somebody will point on that particular cases. It's very unlikely to happen. So, and it was in a very late stage, so it was not possible to do it. And definitely one of the aspects that can be done at drafting level and to identify some possible problems with the intent and some possible inconsistencies, or let's say possibly also some loopholes.
Okay, cool. Thank you. It goes to show we start with code in the first place and go through the legislative drafting process from source. That's great. We can iron out these issues. Alice, I've got a question for you. You mentioned that you undertook 3 case studies, the third of which involved translating select provisions of the Copyright Act and also related case law. So the question is, could you please share some lessons specifically around this case study?
Yes, thanks, Natalia. So the short answer is that in our experience, translating case law into machine readable code is complex, and it's certainly many of the legal issues that I touched on in the latter part of the masterclass certainly came into play here. For example, in a recent experiment that we did with Guido, we translated several fair dealing exceptions to copyright infringement, and one of them is for the purpose of research or study, which is Section 40 of the Copyright Act. And the wording of this provision is significant, in particular, the legislature's use of the word research or study. And we noticed that some of the participants in our study encoded these terms conjunctively, so research and study, or disjunctively, research or study, which is potentially an issue. So what we did there was resolve the issue by looking to the case law, specifically the case of DeGaris and Neville Jeffries, and there, which established after reading that case that research and study should be considered disjunctively, and we coded the provision in line with this case. So this just basically is to underline that if we hadn't have taken or undertaken this research following the modern approach, the risk there was potentially deviating from the true meaning of the statutory text as articulated by the courts. And that certainly took time, but it was certainly worthwhile. So yeah, time consuming, but very interesting.
Fantastic. So last question, maybe I could ask you, Alice, to take a law student's approach and Guido from a computer scientist approach. So the question is, what advice would you give to current university law and computer scientists interested in RAC? What skills do they need in particular?
So having done this very recently along with all my colleagues, we certainly found firstly, it's hugely important to get those, certainly the fundamentals down pat, and by that I mean from a, say, law student or law scholar perspective, statutory interpretation, in our particular project, constitutional law, just really understanding, some of those key pillars. Also, I think what was hugely important was a willingness to collaborate, also to learn quite, experientially. We were learning on the ground as we went. We were constantly, making errors, but it's more so a willingness to kind of put up your hand and say, look, I don't think this is right, or could someone else take a look at this? I think that's hugely important. And yes, generally just a willingness. I think if there's opportunities, ways you can get involved with projects at, say, your university, do some research, look around for some academics, reach out to them. I'd say 9 times out of 10, they'd love to hear from you. But certainly just be willing to collaborate and find great external collaborators like Guido, who is an expert in the technical side of things. But Guido, do you want to add anything?
More than the computer science perspective, I think that it will be very, very hard for students in computer science to really be effective in this particular exercise. So they will be very effective on the actual encoding, but they will lack all the legal background, and that is the real risk. So my suggestion it will be that universities should start more collaborations between the law school and computer science faculty or similar faculty, and start to promoting and to create some courses, maybe for both cohorts of students, about encoding legislation. And my guess it might be easier for a law student to take those courses than computer students. So most of the aspect will be very trivial, very simple very trivial for computer science student at the end. So integration with Git, using source control, using the editors, and this kind will be very simple because they might have been exposed to them since the beginning of their courses, but they will struggle in the interpretation part. While the opposite will be true for the law student, but I would say the entry level, and it is possible to create tools to simplify some of the technical aspects, but I don't see ways to create tools to create the art, as Honorable Justice said, how to transform something which is a art into something mechanical.
Fantastic. I'd just like to mention that question was from our lead for our Next Gen program as part of the Society, Jacob Lancaster. So thank you for that question very much, Jacob. Now, just really need to close. I'd just like to say that if you'd like to learn more about RAC projects, please download the OECD RAC Innovation Primer entitled Rulemaking for Humans and Machines of late last year, an excellent paper by Alex Roberts and James Mohan. Also the New South Wales Treasury paper on regulating for New South Wales' future, published in July last year. Now, RAC projects are gaining traction with New South Wales, Victoria, New Zealand, amongst those jurisdictions leading the pack in this area, like with the New South Wales Community Gaming Regulation 2020 being the first regulation in Australia being produced in machine-readable form natively. So RAC is not just theory, we are moving into production. There's a lot to learn, right? And we learned an amazing amount from our presenters today. Just a reminder to join the ANZ RAC Community of Practice, founded by the Society, the Australian Society for Computers and Law, with Code for Australia and La Trobe University. So links will be sent to all who registered for this masterclass. Finally, as leader for the Future Law workstream for the Australian Society for Computers and the Law, it is my absolute pleasure to thank you, Guido and Alice, on behalf of the Society, our community, and those who have joined us for this live stream and on demand. You've done a fabulous job. Please, everyone, be sure to join us for our Future Law RAC masterclasses that will be coming up, further classes, and thank you for joining us.